People versus Eric Martin.
He's waiving his right to a trial by jury. And also, can I address bond, Your Honor?
Yeah, Mr. Martin, you understand that you have a constitutional right to a trial by jury?
I comprehend it. I just want to add, as I told him in an Article 3, Judge, is going to be the choice. First of all, I proved my sister lying before on me with the same type of charge, and it was seen on the camera, she lied. A motion for a judge trial, but I'm going to object to you being the judge based on past constitutional violations.
Okay, well, your motion for recusal is denied. So now, are you electing for me to try the case, yes or no?
In that force, the sense, yes.
Well, you have two choices, a jury trial or me. Out of those two choices, which one do you like?
Are you an Article 3 judge?
Mr. Martin, I'm not going to entertain jurisdictional arguments. So you're indicating to me that you're relinquishing your rights to a trial by a jury, and you'll be tried by me.
I have some other things to say. I enforce my right to a Republican form of government under Article 4, Section 4 of the U.S. Constitution, which is why the court don't have jurisdiction over me. And I am the third party beneficiary here. I am not the defendant.
Can you find
Despite the fraudulent presumption otherwise.
Possible. All right, give us a second, Mr. Martin. I'm trying to get your jury trial date.
I want to make clear, I'll point out, it's supposed to be 28 days, and Saturdays and Sundays are not supposed to be excluded because the 28 days is specific for speedy trials and misdemeanors. And since that's specific under the court rules, it should be 28 days without excluding Saturdays and Sundays or legal holidays.
Your Honor, first of all, I just want to put on the record that Mr. Martin in the past has not wanted my representation of him. Today, he says it's okay for me to represent him. I just wanted that on the record. I also advise Mr. Martin that his arguments that he makes about sovereign citizens and that is something that I can't follow, nor can I ask the court to follow it, just so that's on the record.
I mean, Mr. Gazicki's in the other room. Mr. Gazicki, can you come on in? We'll meet you in the back hallway. All right, Mr. Martin, 1 second.
Yeah, and I got something to say too while we get time in response to what he said. And for the record, the judge has abandoned court. This case is dismissed. I order this case be dismissed. Case number 25-1756-SM.
All right, we're going to set a bench trial.
Okay, Mr. Martin requested that I ask this court if he can have a no condition type bond.
Okay, here's the problem. I'm just going to say it on the record. Request for a bond modification is denied. Mr. Martin had a very simple bond condition that he not go back to the residence. I know he doesn't think I can tell him that, but he's wrong. And he went back to the residence and got arrested again, allegedly, for being at the home when there was a no contact provision in place. He clearly has a history of non-compliance. He doesn't think the court has jurisdiction over him. And the only way I can assure his presence and assure the safety of the community is to keep Mr. Martin in custody.
I have motions to make right now. I have some motions before we leave. Well, first, objection to what you just said, your statement about there's no such thing as an unconditional bond. Yes, it's my right to be presumed innocent under the due process. The due process right to be presumed innocent before guilty. Because I am presumed innocent, that is why any bond conditions violate that right. So
okay, motion denied. What's your next one?
Okay, I motion to dismiss because there is no probable cause. It is her word against mine. She's lying. She's been caught lying before.
If she cannot prove her case beyond a reasonable doubt, the case will be dismissed.
Okay, but anyways, let me finish talking. I didn't finish talking about the motion to dismiss.
I know, but Mr. Martin,
as of right now,
what's your last motion? Do you have one more?
Yeah, you haven't let me finish the motion just based on no probable cause.
Okay.
As the U.S. Supreme Court said in Beck versus Ohio, or is Ohio versus Beck, I forget which word is first, but the probable cause is defined as fact sufficient for the belief. Her word against mine. I told the cop she lied on me. Okay, her word against me. Somebody have her word against mine. That's all there is. So that's not fact sufficient for the belief. There's no probable cause now. The case should be. Come on, let me finish.
Okay, denied.
The case should be dismissed now.
We'll see you back on your trial date. Have a good day.